The Michael Berry Show.
Gerrymandering, the concept of drawing districts for political offices in order to sort of predetermine a result. Is it possible? You bet. Let's say you wanted to get a great reaction to a touchdown by the Patriots when they play the Jets. Well, then play the game in Foxborough, where the Patriots fans will be. Or if you don't, you want people to boo when there's a touchdown, then play that same game at the Jets Stadium, because then you're going to have people that are predisposed toward the Jets. Well, it turns out you can draw districts based on race, for instance, where you can create Democrat districts, Republican districts, and that is what has happened, and that has ended up before the United States Supreme Court. And for that, we go to our expert, and that is Professor Josh Blackman, Mr. Smarty Pants of the South Texas College of Law, where he is a professor to students and well-respected in the media world and the political world as an expert on all things Supreme Court. Professor, this case that came before the Voting Rights Act, if you could be my first-year law student and I'll be Professor Blackman, give me the facts of this case.
Right. So this case arose from our friends next door in Louisiana. And Louisiana legislature drew a map in which they tried to create more safe Republican districts. Almost immediately, there was litigation which said that the votes of various African-American groups are being disenfranchised. And a federal court in Louisiana said you must draw what's basically a district of African-American majority that allows them to pick the candidate of their choice. Okay, a couple of years later, some white voters in Louisiana brought a lawsuit saying, wait a minute, this is racism, right? You are diminishing our votes as white voters and giving votes to others because of their race. So the question is this: can the Voting Rights Act, the federal law passed in the 1960s, require the government to consider race and basically give these districts to certain minority voters at the expense of other voters who are not members of that group?
Okay. I'll ask some very basic, simple, obvious questions because you'll know the answer, and let's get it all out there. But this has been done a long time to redress past grievances of Jim Crow.
Right. And the argument is the Voting Rights Act was passed to, as you said, address long-standing efforts to
I said redress, Professor. I said redress. To redress long-standing grievances and long-standing efforts to dilute the votes of African-American voters. The argument now is it's not 1964, it's not 1984, it's not 2004, it's 2025. And the Supreme Court has said a lot of things about race. For example, they said a couple of years ago you can't have affirmative action. You can't judge people based on their skin color. I mean, one of the weird parts of this case, Michael, is it presumes people who look alike vote alike. It presumes that people who have the same racial identity will always vote for the same candidates, which are invariably Democrats. So it's sort of this very weird racial stereotype which the law requires, and the argument now is this itself is unconstitutional. Well, let me first say that the only reason I brought up the issue of redress is it was a Jeopardy topic a couple of weeks ago, and under the heading of double meanings, it was to apply your clothes a second time or to fix a past problem, and it was redress, and I got it, and I was so excited, so I needed to use it with you. You're one of the few people that I could say redress or redoubt, and you wouldn't even flinch. Well, but here is the problem, Professor. There is the law, which is blind, or we hope it is. The famous sculpture of Lady Justice, and that's nice, but we know that it is actually true. Blacks do in every study typically, other than when Trump is the presidential candidate, and it's still overwhelming, blacks do typically well over 90% vote Democrat. So in reality, if you clump a bunch of you clump a district full of blacks and you draw it so that you only have blacks in there, you're going, historically at least, you've been able to elect Democrats out of that. I mean, how do we address that?
Well, I think that's exactly the problem. It only goes to the benefit of one political party, the Democratic Party. If you're a Republican in Illinois, a Republican in New York, there's no way you go to court saying, hey, they're diluting my vote. It only works one way.
And I think what Louisiana says, we're not trying to disenfranchise black people. We're trying to have a Republican supermajority. And so up north in Illinois, they can make Democratic supermajorities, but in Louisiana and Mississippi and Alabama, they're forced to give Democrats seats. I mean, Michael, if you actually look at the numbers, if the Supreme Court rules the way we think they're going to rule, there are 12 Democratic districts in the country that just vanish, that exist only by virtue of the Voting Rights Act. So it's sort of this asymmetry, this unequalness between the North and the South. You know, if you are a white Democrat in West Virginia in a solid Republican state, you have no luck. But if you're a black Democrat in Louisiana, where also you're a political minority, you can go to court and demand a district. So I think what the Supreme Court's going to say is the rule should be the same nationwide. We shouldn't have this carve out for Democrats in the South, Republicans in the North lack.
Well, and we did have a carve out, didn't we? When what comes to mind, I don't remember it when it happened, but I've studied it thoroughly, is the 18th Congressional District that was basically created for Barbara Jordan in Houston, which included east of downtown, probably where you're sitting right now, which was downtown, and then east of downtown into black neighborhoods. And it picked up a piece of downtown, which made an interesting collaboration between white Democrats, many of whom would become Republicans later, and Barbara Jordan, who was an acceptable black candidate, not a rabble rouser, unlike Curtis Graves, the candidate who ran against her, and he claimed that she was an Auntie Tom because she was owned by the white downtown interests. She went on to serve with great distinction, and as you know, she was the keynote speaker at the 76 convention that nominated Carter, and then again in 92 for Bill Clinton. So of black congressmen, Democrats, there is no Democrat black congressman who has served with greater distinction than Barbara Jordan. There's no question about that. But she was the beneficiary of a district created for a black candidate in sort of compliance with the Voting Rights Act. I mean, I think we can state that we can stipulate that as fact, Your Honor.
Absolutely, yes.
So
yeah.
The point, I got a little distracted because I love the story of Barbara Jordan, but I got a little distracted over the fact that the Voting Rights Act did impose two systems. It said, you know what, Southerners, y'all are bad people. So we're going to make new rules for y'all. We're going to impose these things upon you because you've been bad in the past. And I think that doesn't sit well. And I also think that's un-American.
Yeah. I think the lawyer for Louisiana is Ben Aguinaga, who clerked right here in Houston for Judge Edith Jones, brilliant lawyer. He said, look, we acknowledge the bad deeds that were done in the past. We can't outrun our history. We can never get away from the sins of our ancestors. And again, we are 50 years from the Voting Rights Act, 60 years. At some point, we got to say times have changed. The world's a different place. And Louisiana legislature is not acting based on racial hatred. They're acting based on trying to create a Republican supermajority in the legislature, which is what most states try to do. And if you start from that premise, then there's no evidence there's an intent to harm black voters. They're trying to harm Democratic voters, right, who happen to be black. So what I think the court will do is they're going to say, let's get out of this business. The Illinois is up north. Up north, Illinois can make their Democratic supermajority. In Louisiana, can have a Republican supermajority, and let the political chips fall where they may.
The esteemed Professor Josh Blackman of South Texas College of Law is our guest. More with him in just a moment.
Ladies and gentlemen.
Don't use that tone to me.
Not a joke.
That sarcastic, contemptuous tone that means you know everything because you're a man and I know nothing because I'm a woman.
That is not a joke. That is a natural fact.
The Michael Berry Show.
Professor Josh Blackman, a.k.a. Mr. Smarty Pants of the South Texas College of Law, is our guest, where he is a professor and well-respected. You've seen him on...
This call is being recorded.
Fox News. Did you mean to do that?
Oh, that was... I'm sorry. I did it by accident. I hit the thing on my phone. That was an accident. I'm sorry, Michael.
Hilarious.
And I should tell you, do you know what my daughters call me? They call me Mr. Farty Pants.
Oh, I love that.
You call me Mr. Smarty Pants. My daughters call me Mr. Farty Pants. So that's I give you credit for that one.
I got to tell you, I miss my kids being of the age where you could say the word fart and they would start laughing. You could make them laugh at anything.
Funniest in the world. It's a funny thing. They love fart. They just love it. Oh, and also, Michael, we got another baby coming in December. We're very blessed. So I'll have another. We'll have to do another call on changing my baby's diaper. We'll do that one again.
Elon Musk will approve.
Above the replacement rate.
Professor Josh Blackman is our guest. So if this case is ruled to strike down the Voting Rights Act application that creates this gerrymandering. The talk is a flip. 12 districts that were gerrymandered to be Black Democrat seats. Jasmine Crockett, of course, being one of those. Al Green being one of those. That they would very likely lose their seats, and that would mean a flip to Republicans of 12, which is a net effect of 24. That's a pretty dramatic change in the House of Representatives. I mean, a dramatic change instead of being neck and neck, which it is now about 50-50. That would take effect immediately. And what am I not thinking through in terms of the administrative, logistical issues involved here in applying that ruling if it happens?
I don't know how quickly it can happen. So the Supreme Court will decide this case in June of 2026. The midterm elections are November of 26. I don't know if you can get them all done that quickly. I think realistically the primaries are happening now. You would have to basically redo some of the primaries because you're redrawing the map. So I've seen some estimates saying that it could be done. The Louisiana legislature is holding a special session like in July of 26. So as soon as the Supreme Court decides, they're going to fix the maps. I don't know nationwide. But just one interesting thing, Michael, about these maps, in order to sort of pack all the minority voters in a single district, they have these maps that kind of stretch from from Baton Rouge up to like Shreveport. It almost stretches the entire length of the state. For people who are completely dissimilar, they're not in any way similar other than their race. It's just kind of this very weird, what's a gerrymander? Use this word. It's this fascinating word. It's this ancient word where someone drew a map that looked like a salamander, kind of this snaking serpent going through the state of Massachusetts. It was named after a guy named Elbridge Gerry, so they called it a gerrymander or gerrymander.
Right.
It's just a very weird way of drawing maps. It's been around since the time of the framing of the Constitution.
Yeah, it's one of my favorite words in political speak, and it's a great story behind that. And like you, I always, if I'm giving a speech and a question comes up with regard to how districts are drawn and how politics is played and how you talk about a threat to democracy, it is antithetical to a true democratic republic because you're not representative in nature. You're now jiggering with the process, which makes, in my opinion, a mockery of it. And so I always tell the story of how gerrymandering came to be, as you just did, and how funny it is. It was actually pronounced Elbridge Gerry, as it would happen. You expect, if I forced you right now to tell me the ruling, is this a 6-3 or a 5-4?
This one's 6-3. This one's not a hard one to predict.
Really?
Yeah, some cases are hard. This one's not hard.
And that's based on what you've heard them say so far?
Yeah, the argument's been about 2.5 hours, and there was not a single doubt from the conservatives. How they write the opinion, I'm not sure. There are different ways they can go, but Louisiana wins this one. And I think, again, it may be 12 districts that get redrawn. Maybe it's 10, maybe it's 8, maybe it's 6, maybe the standards are different. And, Michael, it's not just congressional districts. I live in Spring Branch ISD. There's a voting rights challenge to our district in Spring Branch ISD. And if the case goes this way, I think the voting district, Spring Branch ISD, stays the same. There was a judge who was about to make us have all large elections for our school board.
Right.
I think that case probably goes away.
Yeah. So this would affect the at-large and district
Everything.
races distinction
Nationwide.
as well.
Yeah.
Wow, that I did not realize that was applicable to this. That is most interesting. Professor, while we have you, we've got about 3 minutes. Are there any other cases out there brewing that they've granted writ for that you think or granted cert for that you think we should keep an eye on?
Yeah, so the big one will be argued soon as a tariffs case, whether President Trump's tariffs are lawful and whether there's the power to issue them. This is one of these cases where if the court rules the tariffs are not legal, in theory, Trump has to repay the money. He's basically said, we don't have the money to give back to these various companies, foreign countries. We don't have the money. So I'm not quite sure how you unwind that one. That could be a mess. Another big case was birthright citizenship, which we argued later this year. I think Trump's going to lose that one, but maybe he knows that. Very big case about the president's power to fire people. Trump fired the commissioner of the Federal Trade Commission, which is a so-called independent agency. And Trump's going to basically say these are all unconstitutional. You can't protect people in these independent agencies. I'm the president. I control the executive branch. I should be able to fire people. So these are 3 huge cases like birthright citizenship, tariffs, president firing people, plus Voting Rights Act. This is going to be one of the biggest terms of my lifetime.
That is, the problem is I find myself like your students in rapt attention with what you're saying, and then you just come to an abrupt stop, and I didn't think about it ahead of a question. I was actually paying attention, which is very rare for me. Very rare indeed. I want to go back to the Voting Rights Act case. Clarence Thomas, my favorite justice, and the second most important political writer thinker of our day, the first being Thomas Sowell, making the interesting scenario that the two most influential thinkers of our day are both black, and that should be celebrated. But of course, it isn't because they're conservatives. He had some things to say yesterday that garnered a lot of attention. Your thoughts on how influential that will be to the rest of the court?
Well, I think Justice Thomas has a certain, prerogative. He grew up in Jim Crow South. He saw in Georgia what the world was like, and he rose up in the world. He married a white woman. He did something that would be illegal when he was born, right? And he's truly sort of risen to the top of the legal thinking. I think Justice Thomas will go further and say, as you said before, that we need to get out of this business of judging people based on their race, that these stereotypes, and you might be right that black voters lean Democratic in high percentages, but to sort of pack them in a district for the sole purpose of electing Democrats is almost unconscionable. It's just disgraceful the way that's done. They're just basically, pawns to vote a certain way. Who cares if, you're a farmer up by Shreveport or you're city dweller in Baton Rouge? You're all the same thing, right? You're all together.
You're first and foremost, and at the end of the day, essentially just black. It's treating blacks like pets. I've said this all along. As you said, I use the word pets or livestock. Talk about chattel. It's treating people as if they're not individual human beings.
Yeah.
It's as if they're nothing more than the sum of their skin, which they were born with. And I think that is the most insulting thing ever.
Yeah, Justice Thomas says every person is born with the dignity of his Lord and Creator, and we're all individuals. We should not be treated in this stereotype fashion as just another part of a political machine. And I hope the Supreme Court does the right thing and then frees us from this regime.
You're about to make me quote one of my favorite lines from Thomas Jefferson that is on the Jefferson Memorial, but I'll spare you that because we're out of time. Professor Josh Blackman, a.k.a. Mr. Smarty Pants, and today we find out another alias, Mr. Farty Pants, to his kids. And congratulations on your forthcoming child. That is delightful news. I'm glad to hear you. I'm glad to break that here on the show, and we look forward to having you back again. Professor Josh Blackman, South Texas College of Law Supreme Court expert.
Thank you, Michael. Bye-bye.